I plead the fifth.
And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day, false allegation, just machine. I give over everything. I've done this for 33 years. I've never read a case like this.
And I got a problem with you now. I would suggest you don't say anymore.
I've already said.
Okay, hey, everybody, calm down, everybody.
Day 86 and 87 of the Young Thug YSL RICO trial was absolutely insane. Kenneth Copeland, aka Lil Woody, is an infamous snitch who talked to the police on interrogation footage for over 3 hours back in 2015. He takes the stand and invokes his Fifth Amendment privilege, which ultimately means the judge must hold him in contempt and put him in jail. This day is literally chaos. I'm actually speechless. Towards the end, Brian Steele even basically says he hates Miss Love, and he says that she makes him hate coming into work every day. I don't even know what to say. I'm speechless. Just watch the video. Watch the entire video. Hit subscribe. Here we go. First look at Thug on day 86. Got a nice sweater on. He's smiling right now because they're bringing in this guy on the left right here, another guy that's just helping a student, a law student right here. But
after a person has identified where their vehicle that they've rented is located on that board, would they have to interact with any representatives at that time?
So at that point, for me to switch that Corolla into something that would be more suitable for my size, yeah, I would have to go inside and see someone, yes.
Okay.
all right, so they're testifying to a lot of bullshit, trying to really hammer it home that Thug was the guy that rented the car and drove out of the Hertz location with the car.
This would have came from corporate. They asked to pull rental agreements, records for this particular renter.
All right, Thug's lawyer Keith Adams up for cross.
You circled that and you said that looks like an Infiniti. Is that right?
Correct.
Right. Tell me from the photograph that you're looking at right there, who's driving that Infiniti on that date, January 10, 2015?
Can't answer that.
You can't tell, can you?
No.
There's no way that you can look at that photograph and tell anyone here that Jeffrey Williams or anyone else is driving that vehicle at that moment, can you?
No.
Classic Keith Adams here, doing what any lawyer would do, pointing out that this guy doesn't really know who was in this car.
What individuals were actually working at the location on that particular day?
So the 400 employees.
Yes.
Couldn't tell you.
You don't know?
No.
All right. Drive-out location that we talked about where folks, you'll say have to stop before they leave with a vehicle. Cameras there?
Can't answer that.
From the amount of time that you've worked at Hertz, that people rent vehicles all the time and let other people drive the car.
That's true.
Is there anything about any of those items that tells you who was driving the rented Infiniti on January the 8th of 2015?
No.
Is there anything about any of those items that you were asked about that tells you that you can definitively say to this jury, I know who was driving the vehicle on January the 9th of 2015?
No.
Do you know where Jeffrey Lamar Williams was located? In what state he was located on January the 11th of 2015? Do you know?
No.
Do you know who was sitting behind the steering wheel of that Infiniti when it was returned back to Hertz on January the 11th of 2015?
No.
Did you know Jeffrey Williams?
No.
You ever met him?
Personally?
Yeah.
No. Wait, hold on. Can I go back?
Sure.
I know who the rap name is. I didn't know Jeffrey Williams, so no. Young Thug, yes.
Okay. When you say you knew who that person, who that entity was.
Yes.
You never met him personally.
No. Lifestyle had just dropped. Everybody knew that song.
Oh.
Banger.
And you liked it, right? Withdraw.
He said Lifestyle just dropped, and everyone knew that song. Banger. The fact that the judge overruled that is funny too. All right, on to day 87. Yesterday was boring as shit. That's why it didn't have its own video. So on to day 87 now, where it gets really chaotic with YSL Woody takes the stand, boys. Here we go. There's Yacht Gotti, accused of being in the rental car, part of the Donovan Thomas murder. Shannon Stillwell, the alleged shooter in the Donovan Thomas murder. Got the clear glasses on like me. The judge on his computer ordering dinner already. First look at Thug in a black suit and black tie. Woody's lawyer right here.
So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
We have only spoke to Mr. Copeland as it relates to his being a witness in this trial. Mr. Copeland was subpoenaed a few months ago, but as we were getting closer to his testimony, we resubpoenaed him again last Friday, which was a week from today. When we met with him, we spoke with him briefly. I believe I asked him if he had an attorney or Mr. Melnick was his attorney. I believe my understanding from Mr. Copeland was that he hadn't spoke to him or that he wasn't his attorney. He came down here, we spoke, he asked us questions, we answered his questions, and we moved forward. At no time during any of those conversations that we had with Mr. Copeland that he advised that he wanted his attorney there. We would have obliged that, but I believe that we were having good conversation as he's a witness in our case. And then it was not until 6 o'clock last night that I received an email from Mr. Melnick, copied Mr. Schardt and Mr. Steele on that email, and advised that his client was going to plead the fifth. In the state's conversations with Mr. Copeland, he had some concerns, and we had told him just in general conversation that we would give him use immunity to testify in this trial.
So he has immunity in the state of Georgia, but apparently he can still be charged federally. So that's a little sketchy. The state has to notify the defense that a witness is going to plead the fifth if they know it.
If Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
He is present in the courtroom, Judge. What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Mr. Copeland, come on up and have a seat here, sir.
What an insane fit to wear to court. Some Timbs, white pants, and a plaid shirt.
All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you?
This is intense. He's in a courtroom and he snitched on a lot of people in this courtroom. Put them in the car. I'm pretty sure he wanted to wear wire or FaceTime Thug to get Thug caught. Take down everyone in order to not go to jail. He's terrified of going to jail.
Use immunity?
Yes.
Do you have a copy of it?
Yes.
You've been subpoenaed in this case to appear before and give testimony in this particular matter. State has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they want in this case for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. If you don't testify, the state's probably going to ask me to jail you, and I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the Fifth.
Okay, you're taking the Fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's giving you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question that implicate me, then...
Okay, they can't prosecute you on that. They can't.
He doesn't care about being prosecuted. He just doesn't want all his snitching to come out in court because it's going to be crazy.
The state can't use that testimony. They can't kind of say, have it both ways. Like, you testify and then use that against you to indict you and prosecute you.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him. So I testify.
You will testify.
Yeah.
Huh?
All right, sir. Okay, what we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. We'll formally administer the oath to you. And then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially...
Can I speak my attorney before? Because I think I just said the wrong thing.
Sure. I'll tell you what, why don't you step outside and talk to Mr. Melnick.
I think I said the wrong thing. Come on, bro. I wonder what Thug thinking. This man snitched on me. Is about to come out in court. He's not trying to testify now. Ryan Steele has something to say about all this.
I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me, to everyone on the defense side. But, Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So, God forbid, the killing of Mr. Thomas is at 7:22 approximately, January 10th, 2015. By the early morning hours, I'm going to tell you about 4 in the morning, Mr. Copeland is on video, audio recording with Detective Thorpe. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on, been inconsistent. So, anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady.
And I provided that information to defense counsel. Outside that, the state doesn't have any notes, and so there's nothing else to turn over except for what I did turn over.
You swear affirm testimony to report the truth, the whole truth, nothing but the truth.
Yes.
Let me see. You state your first and last name, but them both, please.
Kenneth Copeland.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here.
Okay. Well, are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the Fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please?
Bro acting like he not on camera snitching already, though. He's going to jail, man.
Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
This guy George is a reporter in Atlanta, and he pointed out something that's pretty bad in my opinion. Court officers instructed Sylvia and I not to record or photograph the arrest. What? Court officers do not have the power to do that. Only the judge has the power to do that. Parties and spectators may use recording devices to record proceedings only as specifically authorized by the court pursuant to this rule. All parties and spectators shall turn the power off to any recording device while present in the courtroom unless the judge allows orally or in writing the use of recording devices in the courtroom for purposes other than recording sounds and images. So basically, this is not good that a deputy did that, and also the state knew he was going to do this.
Jury is excused. Would you please entertain a motion for a mistrial?
And here's a motion for a mistrial from Brian Steele. Let's see what he says.
Mr. Steele, I'll entertain it right now. The basis for your mistrial. We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question, so at this point in time, there's really, I mean, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
Everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. I mean, the last thing the court knew.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al. This trial's been going on now, I believe, 8 months in front of a jury. They've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No, so the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's the killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial.
Okay. All right, sir.
The judge doesn't care. It sounds like the state knew because of this right here. I note that 2 sheriff's deputies pulled me and Sylvia out of the courtroom to tell me that if Copeland were arrested, that we're not to take pictures or have sound. That strongly implies that those sheriff deputies had a reason to believe he would be arrested. So clearly they knew that he was going to invoke his Fifth Amendment right up there and get arrested. Also, Thugger Daily tweeted this: deleted social media post from Woody during the lunch break. I'm good. Stop calling me. I ain't crying at all. This is my last jail time. I love y'all and I have to take this trip. My head high. Nobody didn't force me to, and I'ma be good, okay? God didn't bring me this far for nothing. It is what it is. I'll be okay.
Mr. Copeland's communication to us that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. We have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants. Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in.
Does at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland?
Holy shit. So she's saying the defense influenced his decision.
The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses, this particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented. That interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks, and after Mr. Copeland has communicated to this court, he will testify. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interest he's representing. Starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning.
He said, though, at the end that he thinks he said the wrong thing, so let me talk to my lawyer. Doesn't that indicate that he didn't mean that he said he's going to testify at first?
Motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County jail. So, Your Honor, I would ask that the court deny the motion for a mistrial. Mr. Copeland was at the point right before lunch agreeing to testify. That is the reason we were ready to get started right before lunch, because now he's been told he's going to be hammered by his attorney.
I'm going to deny the motion for mistrial, Mr. Steele, at this point in time. I'll note that you've made it.
My understanding is I'm going to proffer a great investigator who is looking at me and I trust her. I'd like to call her as a witness. I was told I was not there. Heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior, state, and if I have to go to jail, then lock me up. Now, David Boss told me as I was walking in that he heard, and he's right behind me, so he should be speaking for himself, but he heard Kenneth Copeland tell the prosecution, I said the wrong people, please correct it, that he's invoking the Fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements, okay?
Uh-oh, Max Schardt standing up. You know, every time Max Schardt stand up, something happens, bro. Apparently you pronounce Schardt like shard, I think. So I've been messing that up for the whole trial.
I'm just telling the court that in order for you to deny my motion for a mistrial, this is bad.
And I'm going to deny your motion, and I've made my ruling. I'm done at this point in time, okay? In terms of this motion for mistrial.
I'd like to call the witnesses, but I understand what you're saying.
I'm not going to call any witnesses. I don't need any witnesses. Your proffers are fine.
We are in a side room off the hallway on the first floor. That's where defense counsel, it's kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach, and I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. I believe agents from the state were present within earshot, and that gentleman on the phone, who was Kenneth Copeland, was making
How do you know it was on the phone? If Kenneth Copeland's on the phone, was he talking on the phone, or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular purported conversation.
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business, and I was
but
no interactions.
I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is.
I believe that the state was on notice that something like this.
Okay.
So the defense thinks the state knew this was going to happen. The state saying, no, his lawyer changed his mind and said we're gonna hammer him. Let's be honest here, the jurors go home and watch some of this shit. Some of them do, at least one or two of them do.
I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do, both sides need to do this. Do not let outside influences influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. These witnesses will testify to whatever they're gonna testify to. So
the defense has done nothing.
I didn't say you did anything wrong. Okay, but I didn't say you did anything wrong, but okay.
Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I thought we.
I don't know of any defense counsel that's had any conversations with Kenneth Copeland at all, and I just want to make that clear.
He's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer, and that lawyer can make that decision, and so can Mr. Copeland. So,
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland, and I found communications as late as June 5th of last year, where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
The judge isn't going to care about any of this. This is just going to proceed. Kenneth's going to come up there next week and just keep saying he doesn't know anything or plead the fifth. He's just going to, like, it's going to be a complete waste of time, but very entertaining.
Copeland is in custody right now. It's because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Ms. Hilton and Ms. Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland, about Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
when did you talk to Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney.
Oh boy, that isn't good luck for this lawyer. Let's see what he says.
Not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after.
That he is subject to being committed and held in the Fulton County Jail until the end of this trial.
With whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to? I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. They even said, the officer...
Then why didn't you as an officer of the court tell me before we took his testimony?
I told Mr. Steele...
No. Why didn't you as an officer of this court tell me?
Well, then that's my...
I got a problem with you now.
What? How is that his fault? It's the state's responsibility, I thought. Is it really equal responsibility for that? I feel like that would be the defense overstepping a little bit.
Well, that's fine. I mean...
I got a problem with you now.
Well,
I would suggest you don't say any more.
I've already said.
I know that, sir. And the problem is you should have told me. If that were your case, then you've just made an argument that we didn't even need to have because I could have certainly asked him based upon your proffer. Now you want to have it both ways? You can't do that.
Your Honor, I thought the state knew that.
And that's not what the point is. The point is you as an advocate is you should have told me.
If they get convicted, they have so many reasons for an appeal, probably in the hundreds.
Let's have an equal responsibility under the rules of professional responsibility.
Okay, as long as we're both responsible, that's fine.
I would ask that, Your Honor, that the deputies transport Mr. Copeland to the jail completely separate from any...
Yeah, I was going to thank you for reminding me of that. In our order, wait just 1 second. In the order of incarceration, I'm going to also have a keep separate order for him.
Your Honor. For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that they did.
I think that that's fair enough, and that's a good suggestion.
Yeah, he is not safe in there. Woody is not safe in the Fulton County Jail, dude. If I was him, I'd be so sketched out. I'm like, dude, keep me in a cell for the whole time. I don't want to be near anyone.
But we'll go ahead and have him. If you could also have him housed separately too.
And we are again missing. We do not have the complete file.
So is he saying Steele didn't send them the complete file or something?
To be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up under headings with some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the condition, in the original condition that it was given to them.
Judge Lambert?
Sir.
You allow another moment when Ms. Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine.
false allegation machine.
I gave the state everything. There's been no purposeful. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8 after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They had everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered. But I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, can we strike the comment
Bro said he used to love going to court. Now Miss Love ruined it.
Okay, everybody, calm down. Everybody, both of you sit. Both of you, please be seated.
Judge, I'm not.
Both of you, please be seated.
You have to do something. You have threatened me with contempt. You threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. We start the case.
Mr. Steele.
I ask you, please.
Mr. Steele.
Please, Judge. How would you feel if you were being treated
Mr.
like
Steele.
this?
Mr. Steele.
I'd like to finish.
Mr. Steele.
I gave him everything on that drive, and it's continual abuse of a prosecutor, of another member of the bar. I don't talk with Miss Love, and that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card. And Mr. Williams, to me, this is an innocent man. You talk about it. Miss Love said there's a man in the Fulton County Jail who shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Schardt. Now it's all because she wants to win a case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023. That was uploaded. Give it to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it. You have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I object.
Try to silence me. I will not be silenced.
Dude, Brian Steele is done. He is so pissed. He's over this shit.
Here's the thing. Okay, I think that Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir, please be seated.
Whatever you do is fine, but I care about Jeffrey Williams.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. Could you all please sit down so I can kind of figure out a solution for this? I know that tempers have been heated in this particular trial and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability. I agree that, there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. We have a large contingent of folks that watch this trial. It sends not the message I think you want it to send. And I'll take up whatever I need to take up as I see fit. But I know that you all, this has been a long trial. It's very demanding, exacting, and grating on and tiring on all of you. And Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence. And I assume that that's what you got. And I'm gonna take that at face value. I'm in no way saying that we're all gonna see each other over and over and over again. And it serves you and serves the profession, serves your clients. It's not effective.
Holy shit. That's it for day 86 and 87. Absolute fireworks. Who's in the right? Who's in the wrong? I'm not a lawyer. I'm just a ginger kid that kind of knows a little bit of things and gives input. This trial is a circus. The state has not laid the best case. I don't think they've really proven Thug to be the head of a gang in this enterprise at all. I wonder what the jury's thinking. They definitely go home and watch this. I really think they do. I feel like it's inevitable to see something on social media, but hit subscribe. Love you guys. Comment down below your opinion on what's going on. Peace out.